I'm Drew Stevenson. This is a lecture for my professional responsibility class about ABA Model Rule 1.3, the lawyer's duty of diligence. Now, in Texas, we actually call this by its negative or mirror image. We call it the neglect of a client matter. And violations of this rule, along with the failure to communicate with a client, are the basis for more grievances and more disciplinary actions than any other rules that we study. And so in practice, this is one of the rules that you're most likely to get in trouble for. On the MPRE, if this is tested, it's not going to be an easy question like, can you just ignore a client matter after you've taken it? It's probably going to be one of the subtle points that are made in the comments that show up as test questions. So first, let's look at the rule. This is ABA Model Rule 1.3. A lawyer shall act with reasonable diligence and promptness in representing a client. And so the problem here, what we're really talking about, is lawyers take a case and then ignore it or forget about it or neglect it or just start missing deadlines. They put things off too long, and that violates Model Rule 1.3. In the comments, I'm just going to summarize some of the points that I think are likely to turn up as test questions for you. So comment 1 is about zealous advocacy, and that's when we talk about diligence, we mean zealous advocacy. This is where we get that phrase, and we're talking about dedication, commitment, taking all the steps necessary to vindicate a client's cause or achieve the client's objectives. Now, comment 1 also sets some limits on zealous advocacy. There are boundaries here. And the first is that a lawyer is not bound to press for every conceivable advantage that might be realized for a client. Instead, you're supposed to exercise your professional discretion in choosing the best means to pursue a matter. So the fact that you could have also done something else for a client, or that you could have done something to hurt the other side a little bit more or something like that, is not a violation. The question is, did you take the necessary steps that a professional would take to achieve the client's objectives? Not, was there something else that someone else might have done conceivably? Okay. The other boundary is that you don't have to be a jerk in order to provide zealous advocacy. So diligence does not require the use of offensive tactics or preclude treating everybody with respect in the legal process and giving people courtesy. Now, please note, we have some other rules, some we've already studied and some we study at the end of the course, about the duty to treat the judge and other litigants with respect, to preserve the decorum of the tribunal, to treat third parties with respect, and so forth. So you could end up violating one of those other rules, and the duty of zealous advocacy is not an excuse. In other words, zealous advocacy is not an excuse for being rude or unnecessarily offensive or bullying other people. And in fact, some lawyers get a bad reputation, for being the type of person who's always yelling and swearing and pounding the table, trying to physically intimidate the other party or the other lawyer. And people will start to think that you're just compensating either for the weakness of your case or the weakness of your lawyering skills. Comment 2 is about workload. And when you're in practice, this is actually the most difficult part of this rule, and you need to really keep this in mind. This is the part of the rule I hope you remember when you're a lawyer. A lawyer's workload must be controlled so that each matter can be handled competently. Sometimes solo practitioners hesitate to turn away cases. They don't want to turn away cases because they're afraid that this might be the last client who walks through the door for a while. Like most small businesses, a small firm has clients come in waves, and then you could get a lot of clients all at once and then go for 3 months or 6 months before you sign up a new client. And the temptation is to sign up everybody, and you could end up taking on too many cases and too many clients, so that you end up with some of them falling through the cracks. Conversely, let's say that you go work for one of those big firms when you get out of law school. Well, the associates of big firms a lot of times are afraid to decline assignments from partners, even when they're completely overwhelmed and it's not humanly possible for them to give another client's matter the attention that it deserves. And so you have a duty, no matter how much you're afraid to say no to a partner or explain to a partner that you already have too many things going on, you have a duty to manage your workload. Let's talk about a public defender's office. Sometimes you have a very idealistic person who wants to help every indigent defendant, but you're just one person. You can't do that. And so there's only so many cases you can help or handle before you start shortchanging. You're not really having thorough discussions with your clients. You're not investigating matters. You're trying to settle things quickly because you're under so much pressure from how many cases you have. And so as painful as it is to turn people away, you have a duty to manage your workload so that you can handle each matter competently and diligently. And good intentions are not an excuse. Okay, comment 3 is about procrastination. Some people struggle more with this than others. Procrastination is a major source of client resentment. It can undermine trust. People get very frustrated that you're not moving the case along, or at least they perceive that you're not moving it along, that you take forever to get back to them, take forever to get things done. And the client's interest can suffer. Sometimes in extreme cases, you might have missed a statute of limitations or a filing deadline, or in administrative law, you may have missed a deadline to request a hearing from an adverse agency action, which probably means you're not going to have any judicial review and your client is just out of luck. So if you have a problem with procrastination to the point where the clients are suffering, that's from a disciplinary standpoint, that's going to expose you to discipline under Rule 1.3. So excessive procrastination is a lack of diligence, or will count as neglect of a client matter. Okay, completion. Comment 4 is about completing client matters and when is the matter done. And the assumption is that you're going to carry matters through to completion unless the representation ends first. So obviously sometimes the client fires you or you withdraw from the representation. But normally, if a lawyer's employment is limited to a specific matter, the client-lawyer relationship terminates when the matter has been resolved. Now, note that this is a presumption that when the matter is completed, the representation has concluded. And this question about whether someone is still a client has a lot of implications for other rules and other duties. For example, are you checking for conflicts for former client or for as a current client? Does attorney-client privilege still apply to your communications with this person, and so forth? So watch out for that. Now, what the Rule 4 says as best practices is that you should put it in writing. And clients will often just assume that you are basically their lawyer for life, that you are representing them for all time. And so when the representation ends, send your client a letter saying, "This hereby concludes my representation of you. If you have other matters you need help with in the future, please keep me in mind or don't hesitate to call." If a client has an argument with you over the phone and fires you, there's a lot of people who say things when they're upset, and then later on when they calm down, they assume that you're not going to take it seriously. So if the client said that they fired you, you need to put it in writing. My understanding is that you have terminated my representation and you have a right to a copy of your file, and I will return unused fees or unearned attorney's fees and so forth. Or if you have to withdraw, same thing, put it in writing, cover yourself. Now, this is especially important if there's other phases of the client's matter that could still occur. So for example, you handled the trial, but you're not doing the appeal. You really need to make that crystal clear to your client. Or if you did an appeal and you're not doing the retrial, if you handled an administrative hearing, but you're not going to handle it for judicial review in court, any of those types of things, you really need to make sure the client understands so that they can find someone else to represent them if the matter continues. In fact, violations of this rule often go hand in hand with violations of other rules, failure to communicate with a client, failure to return unearned fees, and so forth. So keep that in mind. Okay, comment 5, we're almost done, is a special rule for sole practitioners that they need to have a death and disability plan. In other words, think about it, the client is dependent on you. If something happens to you, you die, you're in an accident, or you become disabled, you're in a coma, who's going to tell the client? Who's going to tell the court and the opposing party? And you have to have a plan. And that plan includes finding another lawyer who will agree to be sort of your designated successor in the event event of death and disability. And so you have to have a person who's agreed to do it that you designate, and your support staff knows who to contact, who will review the client files, who will send a letter and notify each client that something has happened to their lawyer, their lawyer's death or disability, and offer to continue the matter for them or tell them they can take the occasion to find another lawyer or law firm if they want, and then to kind of triage the cases for those that need immediate protective action. In other words, if you have a trial starting next week, somebody needs to call the court and say the lawyer of record, the attorney of record has died or become disabled and isn't showing up, so we need a continuance. Or to notify the other party, we need an extension or on these motions and so forth because something happened to the lawyer and I have taken over the cases. So watch out for this. I have seen this tested sometimes, and you could have a question about a sole practitioner. You do have, I think, an ethical duty to have a death or disability plan that designates a specific lawyer who's competent, who can come in and take over your cases if necessary. Here's a review question to see if you've been paying attention. A public defender is unwilling to turn away any cases, but most of the cases end quickly in plea agreements. Her workload means she does not have time to discuss things thoroughly with each client or to investigate cases. May she continue accepting new court appointments? Yes. A, some representation is better than none. Or B, no, lawyers must control their workload to provide competent, diligent representation. That's supposed to be easy. Hopefully you know the answer. And if you're not sure, you really should rewatch this video. You might not have been paying attention. That concludes our lecture about ABA Model Rule 1.3.